Hi, it's Mike DelSignore, Massachusetts OUI Lawyer. In today's video, I want to talk about how you read your police report. So you got your police report after the arraignment, and what do you make of it? Almost everyone who reads these reports thinks they're terrible. But recently I spoke to a client and told him that I thought the report was good. He was surprised, saying, well, what was good about it? And I want to explain what I look for when I read a police report. So this is a common situation. A client called me, knew very little about the case. Client said he crashed, told me the court, and that was about it. Didn't remember a lot of the details behind the case. So, initially, when somebody calls, they want to know, what do you think of the case? What are my chances? Well, before I get the report, I really can't make a call on that. Obviously, I told this client, and I would tell anybody, crash is a bad way to start the case. But it's not the end of the case. So I need to see the report and see what I can sort of cling to, what I can argue, hang my hat on to give reasonable doubt. So what I was looking for, before I got the report, I was hoping, well, hopefully he does well in the field tests. Hopefully the observations on is strong. And I knew he was polite and cooperative, respectful, and there's going to be a video. So if those things can be strong in the client's favor, this can be a not guilty. Told me the court, I knew I have a very fair judge, and I got a good jury pool. So I'm in a court where reasonable doubt, the judge understands reasonable doubt. I got a jury pool that I've had success with on all different kinds of cases. So we had the makings for what could be a successful defense. Then at the arraignment, I get the report, and what do I find? I find that while the field tests, when he read the report, he naturally thought it was bad. They said he kept his foot up for 12 seconds. They said he missed some heel-to-toe steps. But being trained as an OUI lawyer, having read a lot of these reports, I know that's a good report because they didn't mention anything that he did wrong in the instruction phase of the one-leg stand. They said he had his foot up for 12 seconds. They said and that was it. But there's other clues on the one-leg stand, how high your foot is up. So his foot was up 6 inches. There's nothing in the report saying it wasn't. So the way I read these reports, and the way any good defense lawyer is going to read the report, is whatever's not in the report, you did right. So they don't put the good stuff you did in the report. That's why when somebody gets their report after an OUI arrest, they always think it's terrible. They always say, oh, geez, this is bad. Because the police don't reveal what you did correctly. So you kind of have to read between the lines. You have to know their training. So this case, let me talk about the one-leg stand. The one-leg stand, he started the test on time, maintained balance in the instruction phase. He was engaged with the officer, meaning when the officer gave the instructions, he was paying attention. He wasn't distracted. He didn't appear out of it. Some of the words we hear when people are thought to be under the influence of alcohol. Kept his foot up for 11 seconds. That's good. It's very difficult to keep your foot up 6 inches off the ground, looking at your foot with a police officer around there. If my argument to the court is going to be, if he was under the influence, he wouldn't have been able to keep his foot up for 11 seconds. It's supposed to be 30, but 11 is good. It's an indication that has good balance, good coordination. Now, this was a case where the report didn't mention what happened after the 11 seconds. So this can go a couple different ways, but in most cases, I'll ask the officer, after 11, he picked his foot up, and most officers will agree. So then we get it to 30. Now, the report never said he got to 30. The officer may or may not remember, but a lot of times when cross-examining an officer, they'll acknowledge that if it's not in the report, then he probably got to 11, and if he did get to 11, I would have indicated that in the report. You might get an officer who'll say, no, will fight me on that, but in a lot of cases, it's going to sound even better than it is in the report. What else do we look for on the one-leg stand? Well, counting. You're supposed to count. There's no mention that my person didn't count correctly. Counted in the correct order. Then the 9-step walk and turn. There were some issues with the instruction stance. This is a stance where you're supposed to stand 1 foot in front of the other. It's an awkward way to stand, but he got back in the stance, and he's supposed to stand in that stance for the duration of the instructions, 30 seconds. So I have someone who initially breaks the stance, gets back on the stance, stands in this awkward position for 30 seconds. So good show of balance, starts the exercise on time, and then misses some heel-to-toe steps. But some heel-to-toe steps, we're talking about 18 steps, 9 up, 9 back. So the report indicates he missed 2 on the way up, 2 on the way back. That means 7 for 9 on the way up, 7 for 9 on the way back. we have someone that basically substantially performed this test. There's some indication he didn't touch heel to toe, but no indication of how far the feet are apart. So in other words, the feet have to be at least a half an inch apart. There's a leeway to this. So a lot of officers don't write that in the report. And I know the court I'm in, the judge will be aware of that, and the judge will hold that against them because you don't know. The tests are very precise. If the tests are scored in a general manner, you don't really know how the person did. So goes up, out 9, back 9. That looks like good performance in my view. In other words, people are doing these tests for the first time. So it's very difficult for somebody to do every little detail correctly. So we have field tests that don't show someone under the influence of alcohol. Now, certainly I had a crash. I'm going to have to deal with that. I'm going to minimize the crash. I'm not going to completely avoid that evidence. That's the government gets to sort of score their points too. They're going to, the judge is going to believe that the driving was bad. I'm not going to really sugarcoat that. I can minimize it a little bit, try to suggest there's other causes, but I can't spend much time on that because that's the government's best part of their case. But I can spend time on the field tests, which the officer doesn't arrest my client prior to these tests. He uses them to determine whether to arrest, and they don't really show somebody under the influence of alcohol. There's my reasonable doubt. There is that, well, maybe he's under the influence, maybe he's not. If we get to maybe, it should be a not guilty. Now, the rest of the case is also good. The client goes back to booking, polite, cooperative, respectful. Now, there'll be nothing in the report usually about the booking, but I know what happens during booking. I've done a lot of these cases. I know that you stand next to the officer for 8 minutes or more while they do the fingerprints. And most officers will acknowledge that the person stood next to them for the entire time, no issues of balance. So we have 8 minutes inside, no sign of being under the influence. We have a photo. We have some questions. They have suicide questions, and then background questions, mother's maiden name, father's name, what you do for work. So all those questions indicate your ability to understand what's going on and respond promptly. The juries in these cases, and the judge, if it's a bench trial, the judge will apply the same law, are instructed that you can consider whether someone responds promptly in assessing whether they're under the influence of alcohol. So I like to draw out that response from the officer. You asked him for his license, he responded promptly. You asked him questions about what he does for work, what mother's maiden name, father's name, you got a prompt response. So all consistent with somebody who's not under the influence of alcohol. In this particular case that I'm sort of using as a framework to show how to read police reports, there's only a moderate smell of alcohol in admission to two beers. So moderate smell, consistent with someone who hasn't drank too much, not the strong, overwhelming smell we a lot of times see in these cases. Field tests, not really indicative of somebody under the influence. We have someone who's polite, cooperative, not belligerent. We have enough reasonable doubt, in my view, for the client to be found not guilty. Now, will that always be a not guilty? Certainly in some cases, maybe a judge finds the accident enough, but it's certainly a case that should go to trial, that I think many cases, most often, would be a not guilty. It's always going to depend on the court, the judge, but this is a case that should go to trial. This isn't a case that I think should be a plea. And the reason is there's not really a huge difference between a plea on an OUI and a conviction after trial. So I think for many people, it's worth going to trial. That's the type of case where we have something strong to argue. There's a good chance of a not guilty verdict. There's no alcohol in the car, nothing, no other sort of aggravating factors, one car accident, no other people involved. So when you read a report, it's important to understand how the police are trained, because the way I cross-examine is I take their training and I know they're taught to look for all these different things, including how you get out of the car, how you hand your license and registration, how you respond to questions, how you do on the field test, which is not just walking heel to toe, but there's 8 clues on the 9-step walk and turn. You got 4 clues on the 1-leg stand, and you can see these clues repeatedly. So I take everything they should find, and then I try to show as much as possible that you did things right. And when we can get it to where, well, you did some things right, some things wrong, that's reasonable doubt. So reasonable doubt means that the government's got to prove the case to the highest degree of certainty in the matter of human affairs. So that's the standard. And the standard for arrest is just probable cause. It's very easy to get arrested for an OUI, but it's very difficult to get convicted because the government's got to rule out every reasonable doubt. prove the case to the highest degree of certainty in the matter of human affairs. So an OUI is basically a crime of opinion, and an officer is looking for just signs to show that you're under the influence of alcohol. And it's really about perspective. Think about it like this. The officer is just taught to look at the case tunnel vision in one way. But when we show all the things that are inconsistent with somebody under the influence of alcohol, we get closer to reasonable doubt. Consider, how an officer is going to look at something, because they do this job every day. They're trained. Their goal is to get people off the road. The last thing they want to do is make a mistake and let somebody back on the road who's not safe to drive. So their bias is towards making an arrest. But we want to show the judge or the jury that, when you look at this from an objective point of view, when you don't look at it with an agenda, you can see all the things that are sort of inconsistent with somebody under the influence of alcohol, and that should provide reasonable doubt, resulting in a not guilty verdict. If you have questions about how to read your police report, feel free to call me. You can send me the report. People text me, email the report all the time. My cell number, 781-686-5924. I'm here to help. It's never too early, too late to call. My name is Michael DelSignore. I'd be glad to go over this, all this information that I covered in this video with you over the phone, and discuss your case in particular.